Helen is a businesswoman, a legal document assistant, and a tax preparer. She's an ardent teacher as well. She's the owner of Self-Help Center, the Judicial Self-Help Center, and she's been providing legal services directly to the public since 1991. Helen has served as a board member, and she's been a member for a very long time, and with CALDA, and we're really happy that she's here with us. She's she has a lot of knowledge to share, and with that, I'm gonna start the presentation. Okay, guys. Thank you.
Hello, hi, fellow CALDA members. This is Helen again. I am so excited, as always, to be able to share what I know. Being a legal document assistant, it is such an honor to actually be able to help you as you help your customers access the law. Remember, that's what we're about. It's all about helping the legal consumer access the law, and we actually are providing a valuable service. So, as always, thank you, CALDA, for this opportunity. All right, I am here today to teach you or to share with you my level of understanding for guardianships. And the type of guardianship that I've chosen to introduce you to or to help you with is guardianships of the estate. I just finished not too long ago drafting or assisting with the guardianship of the estate. So this case is fresh in my mind. All right, so let's get started. Now, again, this is me. You know who I am. And I actually found this. It's about education and preparation for legal issues, okay? So what is a guardianship? A guardianship, as we know, is a court proceeding in which the judge gives responsible adults custody of a minor child, power over the child's estate, or both. Guardianships are often handled in the probate court, but if a child is a dependency of the juvenile court, only the juvenile court may appoint a legal guardian for the child. Only minors may be subject to guardianships. If you need to obtain powers over a disabled adult's estate, or both, you need to seek a conservatorship. And I actually talked about conservatorship in the last class. There are two types of guardianships: guardian of a minor child over that person, or guardianship over the estate. And that's what I'm talking about today, guardianship of the estate only. One guardian can be responsible for both the child and the child's estate. So I will not read you about the guardian of the person. You actually think about why would someone need to become guardian of a child's person? That's because the parents, they're actually standing in the shoes of the parent. So if you have a guardianship of a person, remember, it is not the child's parents who are actually asking for guardianship. When you're doing a guardianship of an estate, it can be a parent. Did you catch that? Usually, guardianship of an estate is usually a parent. So, guardianship of the estate, and I hope you saw that the information that I just provided you on the previous slide, I pulled it up from the Sacramento County Law Library. I love the Sacramento County Law Library because it is a wealth of information for us, and they do make it really plain, okay? So guardianship of the estate. A guardianship of the estate is set up to manage a child's income, money, or other property until the child turns 18. A child may need a guardianship of the estate if he or she inherits money or assets. In most cases, the court appoints the surviving parent, remember I just said that, to be the guardian of the child's estate. In some cases, the same person can be the guardian of the person. I've already said that. But in some cases, you can actually have two separate people. So the guardian of the estate must manage the child's money, make smart investments, and manage the child's property carefully. A guardianship of the estate is created to manage the child's property. It is needed when the child owns or receives valuable property. Like I said, if they inherit it. Remember, you don't need a guardianship if the child only owns inexpensive toys or clothing, or if the child is just receiving Social Security benefits, okay? You don't need that. So this is a plug for CALDA. Make sure you take advantage of the membership benefits that CALDA offers. CALDA does have a guardianship brochure. It deals with the person, but there is some valuable information. It's one of the ways that we can also promote the association to the legal consumer, our customer, okay? So go to the website and download the guardianship brochure and make sure you put your information in. All of my customers, they do get this right after we've signed the contract. All the forms do look alike. And so I'm just here to let you know that a good checklist is always a good idea. The brochure does tell us what documents need to be used. This is just my checklist that I actually do use with each of my customers. So this is just another way. This is just another way for me to actually show you which documents need to be used. We've got the petition for guardianship. That's the GC 210 or the GC 210P. You can look at them. And then we've got the child information for each child. You've got the Declaration under Uniform Child Custody Act. You've got the consent, the nomination, the waiver, and the notice. You've got your duties of the guardianship. You've got the notice of hearing, the letters, and the order. The next slide that I'm going to be showing you is if you have to do temporary. I'm here in Alameda County. That's where I provide services most of the time. And in Alameda County, most of the time, if a guardianship of an estate, our courts have actually said that that's not an emergency. But sometimes if you do need to do a guardianship of the person, you may need to get temporary orders done. And so these are the documents that you would actually use if you needed to do temporary. And remember, just like in a conservatorship, it happens also in probate, where you have to do these 4 documents as well as the previous documents. You turn them in all at once. All right, so our fact pattern, this is real. This is a real situation, and I just wanted to give you some background on it. So the father of 2 minor children died, okay? Mother contacted father's place of employment. The human resource said at the time of father's death, he had a retirement account and insurance policy that named the minor children beneficiaries. Human resource also told the mother that she could not access the account or policies until she was appointed guardian of the estate by the court. Finally, human resource told mom to contact an attorney or a paralegal for assistance. Mother and the minor children live in Alameda County. The reason I wanted you to have this information was to let you know that your customers, because we're not attorneys, and we're glad, right? Because we're not attorneys, our customers, the legal consumer, will come to us and tell us what to do. So this particular customer of mine came and said, I was told that I need to do guardian of the estate. I need to become the guardian of my children's estate because their father died. I'm like, okay, now we can do that, because she actually came and told me what she needed to do, and so now I can process the paperwork for her. All right, so next. So this is why I gave you the fact pattern, because the issue is, where do we file? One of the questions that I asked her was, where do you live? And she told me Alameda County. So probate code section 2201 says the proper county for the commencement of a guardian proceedings for a resident of this state is either of the following: the county in which the proposed ward is another way of saying minor in the probate code, reside, or B, such other counties as may be in the best interest of the proposed ward, okay? So this code actually deals with both your conservatorship and your guardianship. So you know that wherever the minor child, AKA ward, resides, that's where you're going to commence it. It's not where the proposed guardian resides. Where does the child live, okay? This next slide has to do with non-resident. If the minor is a non-resident, okay? And that code should be 2201.5. Copy and pasting, it's actually probate code section 2201.5 is where you get the non-resident venue. The proper county for the commencement of a proceedings for the guardian of a person of a non-resident of this state is either of the following: the county in which the proposed ward is temporarily living, such other county as may be in the best interest of the proposed ward. And then there is a B section to it. The proper county for the commencement of proceedings for a guardian of the estate for a non-resident of this state is the following: temporary, convenience, or such other county that's in the best interest. So now you have three different areas, three different layers of understanding that you can use: where they live, where the county in which the property is located, or the county that is in the best interest of it, okay? Those are the three standards that you get to use. All right, let's continue on. All right, I'm fast. That's all of the PowerPoint. We're now going to jump into the forms, because that's actually what you came here to do, is to actually learn how to prepare the forms. I've already said to you that I work in Alameda County. And because I'm in Alameda County, I am familiar with the process. So I don't know what the other counties do. I don't think I've ever drafted guardianship documents in another county as of yet. But if I had the opportunity, I would. And what I would do is, the first thing I would do is I would actually look up the local rules to see what local rules actually govern the processing of a guardianship in that particular county. In Alameda County, we have a questionnaire that must be completed. I won't age myself, but I remember when there was not a questionnaire. But now that there is, and the questionnaire is very specific as to what you do. This questionnaire used to be, you used to be able to fill it out after you did the filing of the petition. That is no longer true. Alameda County now wants you to actually complete the guardianship questionnaire up front. And I'm going to do a shout out. Debbie, this is for you, because I hope you get to see this. This was the question that you were asking me. How many, if in a guardianship, unlike an adoption, you can have multiple children on one petition. Did I say that correctly? In a guardianship, unlike an adoption that requires a separate petition for each child that's being adopted, in a guardianship, you can name multiple children to the guardianship petition. That means there's only one filing fee. The courts, you know, we're the ones that are actually providing the service, so sometimes we have to get creative. So you have to actually use this form, the guardianship questionnaire. If this form does not allow you to add multiple, because remember, the form is for one child, but you have multiple children. So what I have done is I actually will add the same pages to the document so that I keep one document, but add the information for the second child or the third child. I'll show you what I'm talking about. Be creative. Don't be afraid to kind of mess with the forms, make the forms work. Because remember, somebody was up there making the forms, but the actual application of how you actually use them, they may not understand. So sometimes we can help them, okay? So I'm going to actually share another screen with you, which is my PowerPoint, um, which is the PowerPoint, which actually are the forms. This is an actual case that I actually completed to the end. I got it. It was actually accepted, and everything went well. They actually went very well. When I was actually working on putting the PowerPoint together, it's just the way that my brain works. And I've been providing services for such a long time, right? I was thinking sometimes, again, it makes sense to me to want to see what the end result is. You know, like you got a map and you're going to go to New York. So you know you're going to go to New York. The next question is, how do you get there? That's the process, is how do we get to New York, but we know we're getting to New York. The order is New York. Is that a good visual for you guys? I hope so. Because what I'm trying to say is sometimes if you look at the order that you're after, now you understand what you need to actually get the order completed. I'm going to pause just for a second because I want you to see that a moment. Look at the order for the guardianship. What is it asking for? Based on what it is asking, you know what you need to do. All right? So I'm not going to actually go to the order yet. I am looking down because I've got the actual pages here. And the order for guardianship, it actually says that the court finds, after all the rigmarole as to who's there and all that other good stuff, it says the court finds all notices required by law have been given. Okay, so that means we need the notice of hearing. I'm going to go, okay? So that means we need to do the notice of hearing. There's a notice of hearing. Here's your notice of hearing. That's why this document is here, because the court finds that all the notices have been given. And then it has some other information about 18, all that other good stuff. And then it says the court orders. But let me go back to what the court finds, because there are places in here, because you have to actually give notice to people. We're all familiar with giving notice. We have to give notice. And if you cannot give notice to a specific person, then you have to be able to tell the court why. Remember, what if you don't know who the people are, if you don't know where they are, if you don't know where they are located, you don't have an address, you know, you have to tell the court why you did not give notice to that person, okay? After the court makes its finding, then the court will make an order. And so it says the name, address, telephone number is appointed guardian of the estate. And then it says, it's going to talk about a bond is not required, or a bond is required, or the money will be deposited into a blocked account. So that means when we look at the order and it says that, that means that we're going to have to deal with those issues of the bond. The reason I'm reading the order first is because I want you to, when you look at the petition, you're now understanding why you have to do what you have to do. I have a why personality. If I can understand why, we can get this done. Then so we talked about the bond. And then it goes on in the order, item 11 talks about legal services. And then it talks about the guardian of the estate is granted authorization under 2590 to exercise independently the powers specified in attachment 12. And then the order can also grant powers and duties of the guardian. Okay, that has to do with the person. We don't need that one. And then there are other orders that can be granted. And then there's a number of pages. Okay, that's the order. So now now that we know what the order says, let's go to the actual petition. I'm gonna take you to the petition, but I want you to go back just a few pages with me, because this is a disclaimer, and this is the disclaimer that I send all my customers, legal consumer, to let them know that I'm not an attorney. Keep telling your customers that you're not an attorney. There's no shame to it. We're here to walk beside them and to help them procedurally. This will help you remember that they have a role to play in this as well, okay? And then this is the required notice to consumer. And on my notice to consumer, I tell them, do you know that you have a legal right to represent yourself? This reinforces their ability to handle this. Remember, this is a First Amendment constitutional issue, that the legal consumer has a right to petition the courts for redress. It actually says to petition the government for redress. That's why if the powers could stop it, there would be no pro per litigants. But that sacred document, the Constitution, requires, okay, that they be allowed to do the work themselves. And then my notice to consumer says, do you know that NOLO probably publishes a book that can help you? Because NOLO it publishes those books that are geared for pro per litigants, okay? So all of my customers get these two documents. And it's also a good way to solicit the information that you'll need going forward. I haven't forgotten where I am. I just do talk a lot. You guys already know that. So here's that checklist. And as you can see, I actually checked off the things that I do because I need to stay organized. And we are all, as a legal document assistant, we play with paper. All that paper does look alike. Okay? So this is from my court, Alameda County Superior Court, probate guardianship questionnaire. So someone has called me and they've said they want to do a guardianship. Okay, the first thing that I know that I have to do after I get their money, because I'm not going to work until you give me some money, okay, is I need them to download. They can either download it or I'll show them how to get it. Because this is the form that they're going to complete. Calder doesn't have a questionnaire for guardianship. I checked and there isn't one, but this is the questionnaire. This is the questionnaire. This is in their own handwriting. And we thank God right now because this can be filled out in PDF form. So you can actually type on this document. I remember when it actually had to be printed and then they would handwrite it. And I've always had my customers fill this out themselves. Okay, I can help by helping them understand it, but they're actually going to fill this out. So everyone requesting guardianship, that's a must, that's a mandatory, must do the following. In all cases where the proposed guardian is a relative or not a relative of the child, you've got to complete the proposed guardianship questionnaire and file it at the same time you file the petition for appointment. You do it at the same time, okay? I'm gonna be cute for a minute. I want to see if I can get an annotated one of these annotation tools. I'm learning how to use this, and I hope it'll work. I hope so. Okay. So you have to fill this out, and it has to be filed at the same time. Okay, at the same time. Oops, didn't mean to do that. And then it says, in all cases, send the completed proposed guardian questionnaire and a copy of the petition for appointment of guardian to this person, to this address. Send, okay, and that says all cases, so that's everybody. If the proposed guardian is not related to the child, mail a copy to this address. If these documents are not filed at least 60 days prior to the hearing, you must appear at the court of the hearing and request a continuance. So it's to our benefit to just go ahead and do it. You know, as soon as we get it filed, then just go ahead and make sure that we get this taken care of, get our mailings done. Okay? So then the proposed guardian, I'm spending time on this because it's important, especially if you're providing services in Alameda County, that you do this. All proposed guardians are required to complete the questionnaire, file this questionnaire at the same time as you file the petition, send it to this address. The information provided will be used to prepare the report to the judge on the suitability of the guardian. This questionnaire is also available on the court's website. If there will be more than one child, each guardian must complete a separate copy of the question. Each guardian, not children, must complete a separate copy of the questionnaire. Answer all questions honestly, sign on page 5. If you are asking to be appointed guardian of the estate only, the in-court investigator will interview you by telephone, but there's still an investigation. If you're asking for guardian of the person, the court investigator will conduct a home visit. Everyone who lives in the house must be present during the home visit. After the questionnaire is received, the court investigator will contact you to schedule the home visit. Why am I reading this to you? Because if you're providing services in Alameda County, the legal consumer, our customer, must know that this is what's happening. You're setting the expectations for your customer. You're getting them prepared for it. The court investigator's fee is $800. The fee may be waived under certain circumstances based on financial inability to pay. To obtain this waiver, you must file an application for a court waiver of costs. In some cases, you may make arrangements for monthly payments through Alameda County Central Collection. And if you have any questions, you make a call. So here's the thing, ward, proposed ward, child, same thing, okay? So then here's my petition was filed. This is my proposed question. This is the questionnaire that was completed. My customer did go through and she had the ability, she wrote this out. She had a beautiful handwriting. So it's her job to go through and just complete the questionnaire. It is lengthy. It's lengthy, but it gives them the opportunity to get all the information that you need in order. Again, this serves two purposes. This has to go to the court, but it's also going to help me pull the information that I need for the guardianship documents themselves, okay? So I'm just scrolling through this. Hopefully your eyes don't hurt, but you don't need to actually see this, or I don't need to read all of this because it's just information that you have to give. There is a place on here when we get to the information about the proposed ward. This is where I was talking about. If you have more than one, I would just duplicate this document and not, because you don't need two of them, but if you do need two, it just said you needed two for each proposed guardian. I would even, Debbie, I would actually use the same form, but make sure that those papers that's pertaining to the guardian have their information. You don't want the two that are filed, you don't want them to be separated. And remember, we're dealing with the courts and we know how to operate this. So it's this section 5 has to do with guardianship of the estate, okay? And we actually added an attachment, signed it, and you can see where it says I helped her with this because we went over some information that she didn't understand. It's letting Alameda County, there's somebody out there that's actually helping with guardianships, and they may refer people to you. So this is our attachment for the estate, okay? That we did that for the estate on purpose, okay? So then their progress reports, just their birth certificates are required, do all of that. So now we're at the petition for appointment of a guardian. And remember, it's minors, and it's of the estate. I should have checked that box, but I only put one. Anyway, so petitioner's name, And see where it says here of the person? Remember, we didn't want it of the person, we wanted it of the estate. So no person. This person, my customer, wanted to be appointed guardian of the estate. Okay? And we were asking that the money be placed in a blocked account. We did that right off. We didn't know where the blocked account. She couldn't get any information other than the kids were the beneficiaries of it. So we didn't know what to put here at the time I was actually drafting this. And then it talks about the children, this form, GC 210CA, and I had 2 children, so here. And then here's the petition. She's related to the child. She's mom, okay? And then the kids didn't have any money. So the father of the minor children died and named the children as beneficiaries of his life insurance policy. The insurance company requires appointment of a guardian of the estate in order to collect the proceeds of the life insurance policy. Got that right from her. So none of these other, a lot of this would apply if this was being done guardianship of a person, but we're dealing with the estate. Guardianship of the estate is the easier of the two. It is the easier of the two to process. So then we go down the attachment. Remember, we have to do this declaration under Uniform Child Custody and Jurisdiction Act and Enforcement Act. We're all familiar with this, especially if we do family law. Anything divorce where there's children, we'll all complete this document. And it's the same one. They just kind of change the number on it, okay? And then we're going to do the consent and the confidential. This confidential form is always used. The consent, the nomination, and the consent to appointment, it's all one form. It is just where on the form are you using it. All right, then she's going to make sure she's her own attorney, so I have her sign it. And then she is the petitioner, so I did have her sign that as well. Because remember, she's the mom. So here's the GC 210, which is the actual information regarding the child. And each one of the children, we had to complete for each of the children, okay? Go through it. Make sure you answer all the questions. Okay, make sure you go through. And then you have to, the reason for this number 2 is who are the children's people, who they belong to, their family members, father, mother, grandfather, the paternal grandparents, the maternal grandparents, siblings. Siblings must be notified also, so all the siblings must be notified. And then biological mother. Okay, then we're saying how many different ways, you know what I like, how many different ways can you say the same thing? So we're actually telling the court why, again, we already said it once, but that's okay. We're telling the courts why we actually need the guardianship, which are the same words. Father is deceased, okay? No Indian children, they're not of Indian descent. That's Native American Indian. And then this is for the second child, same information. So, I use essential forms, CEB's essential forms, so it's easy to manipulate the documents for the second child because, it's the same information, okay? And then the personal pronouns, I had a male and a female child, so I just changed the personal pronouns in it. And then we're going to go, this one is a declaration under the Uniform Child Custody Act. In Alameda County, I just want to give a heads up, in Alameda County, we have fax filing, e-filing, where we actually file directly with the court, and it's called fax filing. So on all of my customers' documents, I put my fax number so that after when the documents actually come back, faxing, they come to me. okay? And they will actually file them and send you the face of the first document of every document you file. So the children information, and this form is for one child, but it's more than one. And I love it when I can check this box because all the information that I put at the top applies to the second child as well. Okay, make sure I'm making some assumptions that you guys know how to fill this form out. All right, and then we have, this is, remember what I was telling you about the consent? It's all on the same document, but it's depending on where. So I consent to serve as guardian of the estate of the minor, okay? There's no nomination. And then consent to appointment, we didn't need that either, okay? And then here's the confidential. This is very important. My customer gets to fill this out as well, and then I just retype it to where it's nicely done, but all of her pertinent information is here. Make sure that you read each of the questions to them so that they understand what they're getting involved in. And this document is used for the estate as well as the person. I don't know if you guys ever noticed up until recently this, remember if you were in the class that we just had, the call that just provided for us with reference to trust, we've just had the third part of it. And this professional fiduciary, all right, I think that's an avenue that's open for us if anybody decides they want to go to the next level. What's a professional fiduciary guardians, trust and probates, conservatorships, you can actually, and even of a minor's estate. Go see about it, see what it's about. It's another industry that's available to us because we understand forms. So we're actually the guardianship screening, we had to give some information about it. And if you have to do an attachment, it's just an attachment. And then we have our duties. Make sure that the guardian actually reads this. This is a 7-page document. This one, no, 5-page document. This is a 5-page document. And if you've never read this, you should take the time to read it because this is good information. This is good information as to why we're actually doing a guardianship. Change of address, misconduct, okay? Guardian of the estate. If the court appoints you as guardian of the child's estate, you will have additional duties and obligations. The money or other assets of the child are called the child's estate. Appointment as a guardian of a child's estate is taken very seriously by the court. The guardian of the estate is required to manage the child's funds, collect and make an inventory of the assets, keep accurate financial records, and regularly file financial accountings with the court. So it's not just a matter of we get the money, we get to spend it. No, you actually have a real duty when it comes to your child's money if you become the guardian of their estate. You have to be a prudent investor. You have to keep the money, keep estate assets separate. There can be no commingling. This is very serious, okay? You have to make sure that the money is in an interest-bearing account. If there's a blocked account, and remember we chose to put the money in a blocked account. A blocked account is an account with a financial institution in which money is placed. No person may withdraw funds from the blocked account without court permission. Depending on the amount and the character of the child's property, the guardian may select, the court may require, the estate assets be placed in the blocked account. As guardian of the estate, you must follow the directions of the court and procedures required to deposit the funds into this type of account. The use of blocked account is to safeguard and may serve the estate costs of bond and may save the bond, because sometimes you do have to get a bond. And remember, this particular estate did not require a bond because we put the money in a blocked account. The more you do, the more you'll understand this, okay? The inventory, because we're in a blocked account, because it's the guardianship of the estate, we understand that the inventory and appraisal would be required. We only have to do this once. We did not have to do an inventory and appraisal because we put it in a blocked account. It's just an easier way of doing it. I have had people come to me where they're actually actively managing a child's estate, but I think this was like $130,000 per child. So you might as well just put it in an account that's available for them. And, the guardian can still, if something happens and they needed the child's money, they can petition the court to get some of the money out of the account, but they have to actually do a petition. Insurance, record keeping. This is all under the duties and liabilities, which must be signed. It must be signed by the proposed guardian, which means that they read it. Okay, so, ignorance of the law is not an excuse. You're supposed to know what you're getting yourself into. And remember, I didn't have to tell them this. This is what the form actually says. Okay, so now here's our notice of hearing, estate only, our hearing date. As I was saying, that you have to give notice. So we want to make sure that our notices go out on time. This is so important because you can have a fatal error if you don't get your notices out on time. So we've got our date, make sure that we know how to do my address, the day that I mailed it, I have an attachment as to who I actually mailed it to, and their addresses, okay? And then, okay, so the next document that you're going to be looking at, a girl loves a good checklist. That's not an original statement from me. I borrowed it from someone else, but I love it. We love a good checklist. In your county, Alameda County has a petition for appointment of a guardian. Get the checklist. If your court has one, this is what the examiners are actually reviewing to see if everything that was required was actually presented and filed, okay? So what this tells me, and I tell my customers because I'm a visual learner, I assume that everybody else is as well, that if I can get you to understand the process. So we're going to put all of these papers together. Then we're going to submit it to the teacher, which are the probate examiners. The probate examiner will review all of our documents. If we do a good job, then we get what's called a pre-grant. We get an A on our papers because we follow the procedures. That's an A. Then you get a pre-grant. I just repeated myself. Sorry about that. Next, if you get a B, that means that there are some problems, but it's not fatal. And when I say fatal, that means that there's a continuance. That's what I call fatal. You don't get your order that you were asking for because there was a problem, okay? So in this particular case, my probate examiner, the teacher, she reviewed the documents, okay? And so it says this is not a temporary. So she's going down, she's looking to see what are the problems. You see yes or no, okay? The hearing, okay? Court to set hearing for filing of inventory and appraisal 90 days after the appointment, okay? So we're just going down, we're looking to see what the problem is. One of the problems was the notice of petition was not filed. I didn't file the notice of petition. timing is everything. Timing is everything. So you got to make sure that it gets in. I'm going to go up a little bit just to the notice of hearing was filed on June 13th. The hearing, I think, was very close to it. The hearing was, they posted it on the 12th. They posted this examiner notes on the 12th, that's what I'm saying, and then the hearing was on the 13th or something like that. I don't know what happened, but that's what it's telling us, that I didn't get the notice file. That's what they were looking for, and I'm going to throw it back on the examiners. Sometimes they have it and they don't see it yet, so you just have to make sure that you can get it to the court, okay? And our actual notices, this one didn't say it, but you actually have, if they come out early enough, you have time to fix it, okay? So then the probate examiner is going down, number 2. This, I have the confidential screening report, confidential screen, they're looking at the court investigator's report. There's something, okay? And then the order was not submitted. The hearing was on the 13th. They gave it to me on the 12th. So we did get this order. This order was in. This is when you start scrambling to make it happen. It did happen on the day of the hearing. There was no continuance in this particular file. And remember, these are the letters. The letters come after the order. So here's our order for the guardianship of the estate, and they actually put in, so all the notices were done, scrambled got it done, and then they actually told us that mom was appointed, and then they filled in the information for the blocked account. We had to figure out how to get that money into the blocked account. We needed an order first. Alameda County is kind of weird with this. If you put money in a blocked account, you would think you would need an order, this order. But no, there's another form that we actually needed in order to actually put the money in the blocked account. And this is the order to put the money in the blocked account. Even though you have an order that says it's 2 different ones, and the J.C. Morgan, they actually are more familiar with this document as opposed to the actual guardianship order. So we actually had to go back through and get this done, and you can see this was done in August. Her other document was actually, the order was in June. J.P. Morgan would not accept the order, so we had to actually go back in ex parte and ask the court to, not ex parte as in doing an ex parte motion, because we had some compliance dates, we were able to merge them together, and they actually signed this for us. You can see how much money was actually deposited into the blocked account. Then we had to actually do the receipts. These are the receipts that we were able to get and file with the court, and it was filed September 3rd. And then this is just a copy of the document, the supporting documents. There were 2 children, 2 different bank accounts, because it's for each child, supporting documents. I actually had more than those, but I didn't think you guys needed all of them to show what the check amount was, who it was written to, because the court is now making sure that all the money that the children received was actually deposited into the blocked account. So you actually, what happens is you actually file, you're going to actually get the order for guardianship. My thought was you take that, open up your bank account, but J.P. Morgan would not allow the opening of a blocked account without the order for a blocked account. You go figure. not the receipt. They actually wanted this order to deposit money into a blocked account. You know the law. How many different ways can you say the same thing? If JP Morgan wanted it, we had to deliver it to him, okay? So we received the order for guardianship. Keep up with me. We received the order. This is the order. I started with this document, ending with this document. Now, after you get your order, then you need your letters. That's the document that was in front of this one. This is the letters of guardianship. It's with the order and the letters that you can move forward. You now have authority. If you decide to place the money in a blocked account, what I want you to remember, I said, is to make sure that you actually obtain an order to place money in a blocked account. So now you have two separate orders. And the reason is because that's what the bank required. So we got the order, which had to be signed by the court, and took it over to JP Morgan. The account was established. Then we had to file the receipt with the court, showing the court that the money was actually deposited into a blocked account. And because it's a blocked account, with the receipt, I actually attached a copy of the checks that she received from the insurance company and the retirement account, showing the court that these are the actual amounts. Okay? So after that's done, we're actually finished. We're actually done. So the process from the beginning is to make sure that the legal consumer get your local rules, find out what your local rules are, so that you know if there are any particular documents in particular that you need. Do they have any county-specific documents for the estate? And once you find out the process, then you will actually help your customer understand the process. This is what to expect. Make sure that one of the things that I've learned over quite a while from providing services is that you get to manage your customers' expectations, meaning I always tell my customers that I'm going to do my best, and then whatever my job is to get them to home plate to New York, to get them an order. And I will do what it takes to get them to that place. I get to drive for a little while, but as I'm driving, I'm educating my customer as to what to expect, because they have to go to the hearing. I can't go. And yes, there is a hearing, just like in conservatorship, there is a hearing that she was required to go to. I also tell my customers that if there's a hearing that they must go to, that it might be to their benefit to go before, to actually go and sit in on, I'm actually trying to get you back to the beginning, that they may want to go sit. They may want to just go sit and see what the process is like. It's free. And now in Alameda County, we're actually having our hearings provided via Zoom. So therefore, they can actually listen now. Just listen, because we want to get rid of all of their anxieties before they get there. And then when they get to the court, I'm always telling my customers, let the judge drive. You answer the questions. Because the probate examiner has actually reviewed the document. The judge is only signing it off. It's processed, and that's why, in a nutshell, we're able to provide services, because guardianships, conservatorships, divorce, probate, Anything that is form intensive, there's a uniformity that the courts are trying to maintain. And that's why we as legal document assistants, we are of great value because we understand the process. I look forward to your questions. I will be available to actually answer any. If you have any, I hope I'm saying this correctly. If you have any, why don't you send them in ahead so that I can get prepared. Okay? I hope you enjoyed this class. I know I talked fast, but a guardianship is actually relatively simple. It is. It's relatively simple because, and especially if you think about you're doing a divorce, you know, after you've done it a while, it becomes easier and easier. And it's just a fact pattern that changes a little bit, but you're actually doing the same type of work. Just be timely with it, and help the legal consumer. I I'm done. I'm actually done. So hopefully I'll see you later on this week. Okay. Thank you again. Bye bye.
We have a couple of questions in the Q&A. The first one is Colleen's question with, is the process the same regardless of the county in California? Hold on, you're on mute. Okay, hold on.
Hi. I got a voice. I got a voice. No, I did hear the question. The question was, is the process the same in all counties?
Regardless of the county in California.
Of course not. As the judge told us this morning, we have 58 counties. The documents, the actual judicial council form should be the same, but remember, we've got local forms, local rules. So in any type of action that you're taking, the first thing that you do is actually review your local rules. So there can be some guardianship local rules and local forms that you have to complete. So the short answer is no. Check the local rules.
Thank you for that. The next question is, when you open a probate with minor beneficiaries, should you open a separate guardianship case at the same time?
One more time.
When you open a probate with minor beneficiaries, should you open a separate guardianship case at the same time?
Of course, you know, that's that pad answers that says it all depends. It all depends. So you're asking me, you're actually processing a probate and you've got some minor beneficiaries, and now you want to know who's going to receive the property of the minor. Well, you could. It depends. You could, because, you know, minors can't have any money. I think the number off the top of my head is if it's less than $5,000 or something, you may not. If it's more, you would probably have to. It seems like it would make sense because it all depends on the amount of money.
Okay.
Because it's an inheritance. It's saying that my internet is unstable. What's wrong with my internet? Are we there?
We can hear you fine. I can hear you
Okay,
fine.
thank you.
Once the next question by Patsy, once the minor becomes of legal age, does the guardianship go away automatically?
It does not go, it goes away automatically, but the question is, how does the minor get the money? And especially if the money is in a blocked account, they're going to need an order that says that I've reached the age of 18 and now we can release those funds from the blocked account. Because remember, the bank is not going to release those funds without a court order. So it goes away automatically on when you turn 18, but there can be a process in order to get to obtain the funds. And let me just pick that up a little bit. Imagine if the minor received a home, a piece of property, a piece of real property. Remember, minors can't own real property. So therefore, that house would have to be transferred. The house has been sitting someplace, and now it has to actually be transferred. Okay, so you're gonna have to do something to allow the minor, now adult, to actually receive the property that has been on hold for them when they were younger.
Thank you. Yes.
Hmm.
And then Marie Ramos Fries is mentioning the fee waivers. I don't know that I understand the question in the Q&A regarding the fee waivers, but she's saying, is that based on income?
Fee waiver, yes, it is based on income. All fee waivers are based on income. The question becomes whose income, and remember, minors don't have money, so it would be based on the guardian, And it's like with probate. If you're asking to take care of somebody's money, I personally don't think that you should actually go in with a fee waiver. Think about the optics. You don't have any money, you're asking to take care of somebody else's money. It could be done, but I actually try to dissuade my customer not to use a fee waiver.
Thank you. Next question, anonymous attendee. What is the average fee for this process? Is it the same for one minor as it is for 3 minors? Helen, I think you froze a little bit. If you take off your camera, that might help with the audio, your video. Okay. Let me see. Hold on, she did mention that her internet was acting up a little bit. Stop her video. Okay, so she got bumped off. She's gonna, I'm sure, trying to get back in. Feel free to use the chat to ask questions or the Q&A. And the code for this class is Galaxy. I'll put that in the chat. I believe it's Galaxy. Let me see. Galaxy. Don't ask me why. Hi, Helen. I think we see you back. So let me unmute you. And what was I gonna say? And there you go, we can hear you. Yeah, if it gets unstable again, maybe you can turn off your video. Sometimes that helps with the transmission.
I'm on my phone now.
Okay, perfect.
That's why Tracy told us to use both technologies.
Great. Did you hear the question, or should I?
Yes, please repeat.
Okay, perfect. It was a good one too. Anonymous attendee says, what is the average fee for this process? Is it the same for one minor as it is for 3 minors?
When you ask me the fee for Maya services or the fee to the court?
Both.
Yeah, I mean, the filing fees for the court are the same. It doesn't matter how many minors. My service fees are the same. It doesn't matter how many minors.
Okay. And what is the filing fee for the court?
I am in Alameda County, so it's $465 for the estate. Guardianship of a minor person is, I think, only $200. But remember, that's what the judge told us. We don't necessarily have to remember these things. Always go to the fee waivers guide to actually, I'm gonna turn it this way so I can drop the phone. Actually just go to the website for the court to see actually exactly what the cost is.
And you're referring to the fee schedule that's available online, right?
That's correct. That's correct. And one of the things, there is an investigation for the person, right? There's one for the estate as well. And you have to actually, like I said earlier, you want to manage your customers' expectation, try to give them as much cost up front. I don't know, that's not my job to figure out how much the court investigator is going to charge. So I just make them aware that there is a fee, and then it's up to them to figure it out. Just know that it's going to be a fee, but I try not to quote that price.
Okay, thank you. And then, do you know more or less, have you heard how much LDAs are charging for guardianships, like a range maybe? Or,
Elizabeth, that's your job. You have to give us a survey so that these people, so that fellow LDAs will have a range. I'm going to use my standard answer, okay? And Judge, I heard Judge Yuha this morning. I hope I don't come off overconfident. You cannot charge what I charge. I have been in business for 29 years, okay? So if you're just now starting guardianship, remember, this is in our, we're in a capitalistic society, so therefore it is what the market will bear. So you need to price yourself according to the LDAs in your area. And then I always tell people all the time, please, if you are new to this, for yourself as well as for Calda, start small, because you need to get some customers, the legal consumer, to come to you. You need some real life cases. So tell the potential customer that I don't know how to do this. Honesty is the best policy. Do not hold yourself out as an expert. Helen, how do you say that when you say you are an expert? I don't tell them that. I tell them they don't know what they're doing. I can help you. I'll do my best. But I don't let my customers actually think that I have all the answer. It's going to be a perfect shot. You saw in the example, the notice wasn't there. The order wasn't there, okay? So that means me and the customer, we ran around making sure that it was filed, because there's a person, I try very hard to be very personable with my customers. We're family now, okay? So therefore, just know that I'm going to make some mistakes, because you know why? Because the more I've done this, the more I've provided the service, that's where carelessness comes in at, because you've seen the documents too much. And that's where, remember it said minor, I should have checked the box that says minors. That's just, being rote. So in answering the question, how much do I charge? I charge for a guardianship $1,200. I didn't start off with $1,200. I have worked myself up to $1,200. I am telling you. In fact, if I'm going to turn around for a second, I don't know why I kept this, but I have a price list, and I've kept my price sheets since, this one is from, I can't, 98th West Jackson. And the guardianship on this one was $800. I used to have a lot, my older ones, where I actually started off from. I didn't start at $1,200. I've moved up. The better I became at it, that's when I increased my prices. So
great,
don't start
thank
it.
you. Great, thank you. So next question from Sylvia is, what is considered small for someone that is just starting?
Rephrase that question for me, because I'm not quite sure what you're asking me.
I think you mentioned, I'm not sure, but so I don't understand the question very well, but I think she means that you said maybe charge less for a small case. What is considered small?
Well, I don't know if it's a dollar amount. But I think that you want an easy fact pattern. There's an accident. Somebody was in an accident. Child was in an accident. The child is getting $25,000. You've got both parents. There's not a lot of. You don't have to give notice to people who you don't know or where their addresses are, because that's sometimes that's the complexity. Both parents are together. It becomes a little It's fact pattern based. I think that's what I can say. So I don't know if the amount of the asset is the issue. I have a story though. And I was working
Yes.
for an attorney at the time, and it was a probate. And the father passed away. And because he died without a will, the property was actually going to be 2/3 to the children and 1/3 to the mother. So we have a piece of real property that minors are going to inherit. We already know that minors cannot inherit real property. So it was to the client, I'm going to use the word client because I was working as a paralegal for the attorney, a contract paralegal at that. And so it was to the attorney actually tried to put the property in trust until the minors turned 18. Court didn't like that. The attorney did that. So it was decided that because the children were, close to 18, that they would just sit on the property, not finish the probate. Just let the probate sit there until the children turned 18. Once the children turned 18, now we don't have a minors receiving real property situation. The attorney actually passed away. He died before the children turned 18. So his widow actually hired me to complete the probate in pro per. She was able to sell the property in pro per. The children are now over the age of 18, so they can now sign waivers and consent and all of that stuff. So complexity is what I mean by small, I think, not necessarily dollar amount. But I will say something. If you've got a minor, I'm serious, that's getting $500,000, $600,000, I think you need to refer that on, because there are some real complexity issues in that. If you've got somebody that's inheriting that much money, why are they coming to you?
Great. So every other comments in the Q&A are just everyone telling you how wonderful your presentation is. They're very happy you did this, so we're happy with that. We got 15 minutes. In that time, Helen, since we don't have any other questions, can you tell us about what kind of what would be a good way for someone to gain the knowledge and master their craft if they decided to open their shingle and do guardianships? Like, what would be maybe two either strengths that they need to have, or maybe two good tips? I don't know.
I'm trying, you know what, how did the question, if I could rephrase the question, and I hear the judge. See, I was listening to what the judge was saying. And he said, sometimes we're listening, getting ready for the answer, as opposed to listening. I'm listening to the question. And so what I think I heard you say was, how can a new LDA or someone who's a seasoned LDA get into the field of guardianship? The first question is, where do they come from? Who do I need to make a connection with? Where do guardianships come from? Grandparents are usually guardians. So you could, I'm thinking of senior citizen places, or what else? Where else would seniors be? AARP, introducing your services. Where else? Senior citizens home, retirement homes. Not the assisted living homes, right? It could be, sometimes the guardians can come from, and I'm thinking of persons now. Insurance companies, sometimes insurance companies, hey, I just thought about it. Human resource, because one of their employees died. So you can make some connections to human resources, allowing them to tell you that tax preparers, get connected with tax preparers. Who are the people who see the people who actually may need the service? Notaries, yeah, who need the services, yeah. So, you're the networking that you have, because remember, it was human resource who actually told her to come to me. And the more human resource knows that LDAs and paralegals are available, the better it is for us. They'll be looking for us.
Perfect. Let me check the Q&A. Great answers. Putting them in alphabetical order, so it throws me off to see which ones are the new ones. No, but I think we've asked all the questions. Great. Okay, hold on. What about if you tell the client or consumer you've no idea about your own work, then why do you provide that service?
Say it again.
So I'm reading it word for word. This is Vita's question. What about if you tell the client or consumer you've no idea about your own work, then why do you provide that service?
Well, you know what I hear is, it happened to me yesterday. Someone called me and asked me to provide services for a lien. They need a note and a lien. I'm like, what? I literally said, what? And then they said, well, I told them, I've never done this before. I've got to do a little research as to how to do it. My job as a legal document assistant is to, one, fill out forms and take care of process. I can fill out any forms. Forms do not intimidate me. I can fill a form out. All I got to do is read. Now the question is, what's the process? I can read, so therefore I can go find a NOLO book or find another resource, talk to an attorney, because remember, hey, I just thought about I got another click in my mind. We're business people. We get it done. Just because we don't know something doesn't mean that we can't learn to do it. This is how we can branch out our services. I think what the question may also imply is, why would somebody come to me if I don't know what I'm doing? Well, they don't know what they're doing either. So but I have a business. I have access to forms. I have access to materials. I'm teachable. So therefore, I figure I can do anything, even if I don't know how to do it. I can learn. And my customer who called yesterday, he said he was going, this is too cute. He was going to help me learn how to do it. I'm telling you guys, just because we don't know how doesn't mean that we can't learn. Now, of course, I'm going to charge him nothing because I don't know how to do it. But the next person who calls me that want a note and want to do have a lien placed on property, I'll know how to do it.
Yes,
that's
great answer.
Yeah, that's how I started in probate. I had the probate from hell. This woman was so sharp. She needed me to be a typist. She needed me to help her file the documents, but she knew more about those documents than I did. And it was okay, because I used to sit up and tell her, what are we doing next? What are we supposed to do? Nola was helping. She would read it, I would read it. That's called collaboration. And now I charge a lot of money for probate because I'm learning. So don't be afraid just because I'm gonna stop talking. You got me started on a subject.
We love it.
You don't have to be an expert on everything in order to provide service. And there's an arrogance in thinking that you can't do it unless you know. Law is constantly changing. Process is constantly changing. There are so many different areas of law. So therefore, stay flexible, stay teachable, stay curious. And it's amazing what you can do in your business.
Great. And Vita says, thanks for that answer. And then Rhonda says, let me see something similar. She said, we don't need to know everything. We need to know where to find the answers to everything.
Yeah. That's right.
Yeah. So what makes a good LDA? Not having all the answers. A good LDA is knowing where to find the answer. So that's good.
Yeah, and if you have a rapport with the court, remember, do not promise your customer that you have connections with the court. But you know, once you've developed relationships with the court, they do become your friend.
Mm-hmm. Yes.
We process paper, procedures. We know how to follow directions and process documents.
Yes. And you know, one thing to think about when someone calls you and you don't know how to do that service, and if you turn them away, what's the alternative to you helping them? What are they going to do? They might decide that they can't do that process after all, and you're actually doing them a disservice sometimes in certain occasions by not helping them. People who come to us is because they don't know certain things. So even if you don't know that specific process, like let's say a lien, by you researching it, you know just a little bit more because you know where to find that answer. So if you say, I don't know, but actually you really do know, you do know a lot more than the person on the other end of the phone. So I just wanted to piggyback on Helen's answer. Thank you.
Good job. Good job, Elizabeth. Can do. We can do this. We're business people.
Yes, perfect. And I don't see, and Helen, what is your email address? Is that listed on the conference information? If they go on the conference, they can find your email?
Yes, it is. But remember, it's also in that wonderful Calder directory. I'm listed on the Calder directory. And Elizabeth, I wanted to pick up, we've got, how much more time we got?
It's 12:07 and we have until 12:15.
Elizabeth, let's talk real quick. Let's hijack this conversation, because from the standpoint of what we do, we are legal document assistants. We process paperwork. We're business people. That means that as a business owner, we make sure that everything that the legal consumer needs, when they call us, we are available to do. Okay? And that's so important that we use our business skills, because that was one of the task force. They were thinking about paralegals. Paralegals work for attorneys, and there's an employee mentality, there's a business owner mentality. We're business people, so therefore that means we're working, we're figuring out how to make it happen. We're not just doing one thing. We're broader, and that's what we bring to the table when people call us. Chris, as well as the judge, explained to us about the unauthorized practice of law. It's real, but it is not a barrier. We work around, we bust through, we go over, we go under. We can do this because the legal consumer has a right to get their questions answered. You made such a good point. If we don't help them, where will they go? Where will they go? We can give them direction as to how to learn, where to get the information from. That's a service. I used to not use my hourly rate very well. I didn't want, I grew up in this industry saying that I work, it's all or nothing. I don't do piecemeal. I think I got slapped over the head by realizing that there is a market for people, self-help center. I'll do the documents. I need you to review them. Okay, I will review your documents now. You can upload, and it's so easy now, upload your documents to me. I know the process. I'm not gonna type them for you, but I will review them. I can coach you through this. This is another game for us. We're now sitting at home, we've got the internet, we've got, and it's hourly. It is hourly, and I'm not talking hourly as an attorney hourly. I'm literally telling you, based on what you've given me, based on what you said, whether or not you fill the form out correctly. I'm not filing the forms for you. You're doing this, but I'm actually empowering you to get this done. And I'm surprised. I actually got a customer out of it because she had screwed up so bad. But she tried. She had tried, and nothing
I
beats a
agree.
failure but a not try.
I had the same mentality. I wanted it all or nothing. I didn't want to do one form or two forms. But now I said, if you PDF me everything you've done so far, I will print it and I'll get my red pen out and I will give you edits and send it back. And I'm doing that at my hourly rate. And it actually works out well. You know, they just start stacking up. But yeah, it was a mind shift. And it helps the consumer a lot.
Exactly.
So we are 4 minutes away from the end of this presentation. I did want to take the time to say that thank you for being part of this presentation, part of CALDA. We appreciate you. We're here to provide support for you and just let us know how we can help you. As far as the last question on the chat, they want to know, can you go back and attend seminars after they are done? The answer is yes, because all of these webinars are recorded. You are going to be able to review each and every seminar that you missed in a recorded fashion. It comes with your paid subscription to the virtual conference.
So what's our code? What's our code? What's our
code is Galaxy. Galaxy. I'm not sure why, but it is what it is.
Okay, Galaxy, all in caps.
Yes.
All right, we got it.
All right, well,
sorry about that.
No worries. Let me just check one final spin through the so what is a fair hourly rate for an LDA? And Angela, I addressed that in my workshop, my plug for my Ready, Set, Go seminar class that I did. We really go into pricing. But Helen, if